Good afternoon, everyone. How are you all? Everyone good? Good. That's the last interaction we're going to have today, so don't get worried. I know you're a British audience, you want to listen, not speak. Welcome, it's lovely to have you all here. Welcome to the Royal College of Physicians? Fantastic place. I hope you enjoyed working out what you do with a two-ended spoon as much as I did. Some fascinating stuff out there. Great to see so many people here. Also, I think we've got quite a few people watching on the internet. Hello, everyone. Thanks for joining in as well. And I suspect this is being recorded too. So it's a really good turnout. It's very exciting to see so many people. But it's a big topic. A couple of comments and thanks, first of all. First of all, thank you to our sponsors, IP Centrum, who's kindly put this on for all of us. And Simon de Bank, I think that's how you pronounce the name in particular, from there. So thanks to them for their support for CEPA in this. I was asked to do a couple of quick notices. My notes here just say Brazilian, but that's not a personal grooming list. It's just to remind you that there's plenty of exciting CEPA events coming up, not just the Brexit symposium, there's also the Trainees Ball, which would be fantastic. There's details there. I was asked to remind everyone about the fantastic CEPA Gala dinner that's coming up on the 14th of July. And of course, I personally have to mention the Battle of the Bands. If anyone has a band they want to come, CEPA's Battle of the Bands are fantastic. We've got some grown-up things to mention in a moment too, but I want to start with the important stuff. A couple of quick introductory points. First of all, it was suggested that we start with a show of hands for in and out of Europe. I'll do a third one, which is abstentions as well, out of interest. But we're also going to ask for a show of hands at the end as well. Partly to see if we've changed anyone's minds, but importantly, that's not the point of today's seminar. This is a neutral seminar just to discuss pros and cons and outcomes of different options and nothing more. So let's start with that, out of interest. Are we all kind of counting generally from the panel as well? Who here thinks we should stay in the EU? Who here thinks we should leave the EU? Excellent. So there's going to be some hearty debate. You three can go over here, and everyone else will stay up here. Very interesting. Don't worry, we'll change all your minds during this. We've got a plan. It's fine. No, that was an overwhelming majority. But this is a neutral debate, and we really don't mind if you vote wrong. So as you know. The comments from the panel are a mix of neutral comments. If anybody's going to express a personal opinion, I think they'll mention it. And there's one law firm that doesn't permit you to express a view, just to talk about the potential outcomes of either scenario, which is quite difficult. I think you're probably going to guess what's going on anyway. Another important point is we're only talking about the IP issues today. Anybody here from any smaller parties? Please let's not get political. Let's just talk about the IP issues as well. Apparently, I'm supposed to talk a little bit about how the IP profession can prepare for Brexit, but I'm not going to go on for very long at all because I don't think that's what you want to hear. What I'll probably do most is just to summarise the interesting point that the only two IP bodies I'm aware of that have particularly commented at all are in fact CEPA and ITMA. And for what it's worth, I'm sure you've read their commentary. Both of them have taken a slightly miserable view of the outcome if we were to... Hello, Kilburn and Strode. Great to have you here. As long as they've been billing, I don't mind. I think both the position, both from CEPA and from ITMA, has been quite interesting and pretty consistent, which is to say that it won't be that great for the profession. There's obviously pros and cons, and we were talking about that a little bit, but it was a little bit gloomy. The outcome of an exit wasn't brilliant. But something I think, David, you pointed out to me, which was the very positive ending of the ITMA one, which was that, however, the reputation and trust the UK profession has built up over time, and the potential increase could help make up loss in business, at least in the short term. So keep calm and carry on from ITMA, which I quite liked as well. I'm going to quickly talk you through the running order. So I'll introduce the panel in a couple of moments. They're each going to speak for a pretty strict 10 minutes on a range of topics that I won't take their time up by talking you through. We had a chat about making sure we covered the various options. We thought rather than have questions during, if it's okay, we'll have a Q&A session at the end, just because we've got quite a lot of facts and things to get through. But we're certainly going to build in a Q&A session at the end. And if we've got time, a panel session. We're probably going to run till about 8:30. if that's okay. I was involved in the catering discussion just before. For the 100 people apparently here, there are 25 bottles of beer, so we need to get out fast and get to the bottles. I think that's changed and they've been increased because that's not enough beer, bottom line. So we'll aim for about 8:30, but obviously we'll see how it goes. The other point, just quickly, is to introduce our speakers today, which I'm going to do now. So we're going to kick off with Clive Thorne from Wedlake Bell, who's going to be talking about some of the litigation practicalities, Brussels Convention, stuff like that. David Stone kindly joined us from Simmons & Simmons. We're looking at some of the core rights, for example, trademarks and designs, and much more. Kevin Mooney, you all know from Simmons & Simmons, very closely involved in all of this, so it's fantastic to have that much knowledge in the room, which is wonderful. Talking about the UPC points in particular. Catriona Hammer, IP consultant. We're looking at some of the life sciences side, SPCs, pharma and so forth. And Caroline Warren from Matheson Squire has got the longest list of things to talk about and the shortest slide set, which I'm very impressed by, which is all the other things we ought to think about and whether we should be worrying or not. With that intro, the less I speak, the quicker we get to fight for those beers. So I'm going to hand over now to Clive, who's going to be talking about some of the Article 50 scenarios. Clive.
Yes, do you have the lectern?
I think so, yes, because the microphone's set up. Thank you. It's just the green button.
Well, good evening, ladies and gentlemen. It's a great pleasure to be here. This is entirely apolitical. I've been asked to talk really about two issues. One, the constitutional requirements and consequences of a vote to leave the EU, and also some of the litigation implications, which are universal in some ways, but do have specific, as is always in the case with litigation, intellectual property has always been to the fore procedurally for various reasons. This all came about with the 2015 European Union Referendum Act, which was passed just before Christmas, and that simply says, for material purposes, a referendum is to be held on whether the United Kingdom should remain a member of the European Union. Sets out the question to appear on the ballot paper, but says absolutely nothing about the consequences. There is a process for withdrawal. The government subsequently published a white paper, which I've referred to on the slide, which sets out the process. Section 2.1, or rather paragraph 2.1 of the document, indicates that the result of the referendum will be final, and takes the view that Article 50 of the EU treaty is the only lawful route available for withdrawal. And that is interesting because it was only with the Lisbon Treaty that a specific procedure for withdrawal was included in the EU treaties. I don't propose to go into that in detail. Those of you who want to look at it can see it from the slides. I've set out Article 50 in its entirety. There are some practicalities and some political issues which I think are highly relevant to this. The timeline given by Article 50 is a 2-year period, and if you look at the timeline set out there, there are a number of very important political issues about to take place, which may be highly relevant in terms of negotiating a settlement under Article 50. For example, the French presidential election, German presidential election. It is possible to have an extension of time for that 2-year period. A lot has been talked about trade treaties. Interesting that although the European Union has negotiated on behalf of its members, all the trade agreements are entered into by the individual member state, not by the EU. So theoretically, you have a situation, we decide to leave, but we remain parties to those treaties. Now, whatever that the consequence of that are in practice, the fact is that theoretically those trade treaties will continue in the name of the United Kingdom. It will be necessary to update certain trading terms. I think the general view is that the United Kingdom will have to apply to rejoin EFTA, which we left upon leaving EFTA previously and joining the European Community as it was, it is interesting, and I looked at this, that the EFTA countries have considerably more free trade agreements with the rest of the world than the European Union. Where that gets to, I don't know, but it does, of course, raise the possibility that one simply adopts the EFTA free trade agreements. What I think is undesirable, and I think is not a terribly good course of action, is for the United Kingdom to join the European Economic Area and acquire a status such as Norway or Switzerland, because there are certain burdens placed upon EEA countries which wouldn't apply if EFTA became the free trade area which the United Kingdom then joined. Is that better? Can you hear me? I'm sorry, I'm not used to this. Implications of withdrawal. Of course, we're here to talk about intellectual property, but I've outlined a number of areas which are important, would need to be dealt with in some form. Freedom of movement of people, access to the single market, if we wish to maintain access to the single market, the financial services regulatory framework. What does one do about the common agricultural policy and the subsidies associated with it? Justice and home affairs, replacing the European arrest warrant with a system of extradition as we always used to have. Regulation in a number of areas, aviation, pharmaceutical, which of course is of some relevance to practitioners here, health insurance, reciprocity across the member states, fishing rights, energy policy, foreign policy. That's rather tentative, but the EU purported to implement sanctions against Russia as a result of activities in the Ukraine and North Korea. A lot of these can be dealt with either by repealing or amending the European Communities Act 1972 and statutory instruments which have been passed under the 1972 Act. And I've referred to that in the next slide. And I think the importance of the statutory instruments can't be overestimated. It's the way in which many of these changes will take place. A major issue is the status of judgments of the European Court. And I think there would probably have to be primary legislative change asserting what under English law or United Kingdom law the position of judgments of the European Court should be. Should they be, for example, persuasive and binding upon British courts? These are all issues which would need to be addressed. If there is a vote to remain, a number of practical consequences. Life won't, I suspect, be the same again. The so-called February settlement, which David Cameron negotiated, is really of limited practical consequence because it's a series of declarations with one substantive proposal. The substantive proposal relates to welfare benefits. The rest is largely declarations, for example, that the United Kingdom will be party to greater competitiveness within the European Union, a security declaration, a statement that the United Kingdom is excused from ever closer union. But the benefits provision is fascinating. I've recently obtained leading counsel's opinion upon the status of this, and the view generally seems to be that it's unlawful under the existing European treaties. And it may well be that the welfare benefits provision, which Cameron negotiated, would be struck down post a Remain vote by the European Court. I don't know, but it's a possibility. And then finally, a second referendum. This is a real possibility whilst the European Union Act 2011 remains on the statute book. This was a sort of rather half-hearted measure which William Hague was largely responsible for, which was introduced and passed by Parliament at the beginning of the coalition government, to the effect that if there is, other than immaterial change to the European treaties, those changes will have to be put to the British people in a referendum. And it's probable the European Commission is certainly talking about significant treaty change to cater for the increased requirements of the Eurozone. And we're talking about a timescale of 2 or 3 years. And unless Parliament were to repeal the European Union Act 2011, there will have to be, as a matter of statute law, another referendum in the United Kingdom. Where that gets to, I have no idea, but that act remains on the statute book. Enough said about the constitutional provisions. I want to talk briefly about the practicalities of litigation. I think one of the more convenient provisions which European law has introduced into the practice of litigation is the Brussels regulation. Enforcement, the Brussels regulation is also relevant. In the context of remedies, we of course have an enforcement directive. I think the enforcement directive is of less profound concern because apart from the introduction of publicity orders, the provisions of the enforcement directive largely existed in some form under pre-existing United Kingdom law. But the Brussels regulation, I think, is of fundamental importance to all who practice both in litigation generally, all areas of litigation, family law litigation, commercial litigation, and of course intellectual property litigation. And generally the rule under the Brussels regulation, as it was first implemented in 2001, that jurisdiction is given to the court in the member state of the European Union, which was first seized of the dispute. The 2012 revision largely created an exception for the purpose of agreement between the parties as to which court should have exclusive jurisdiction, and under the revised provisions, that is now recognised. The Italian torpedo, that was an attempt which became quite common, whereby you would bring proceedings in the first available court. You would choose a court on the basis to avoid litigation in a subsequent court. So there is a view that in its original form, the Brussels regulation encouraged forum shopping in a big way and could gunge up the ability of a party to go to a particular court. Arbitration, the European Court in the West Trawlers case indicated that it was prepared to accept jurisdiction in arbitration matters. For our purposes, IP rights, generally exclusive jurisdiction is given in relation to registered IP rights in the place of registration of that right. Enforcement, the philosophy behind that is that you will be able to register a judgment in another member state, and a judgment given in one member state is enforceable in other member states. And the procedure for enforcement is governed by the law of the member state in which enforcement is sought. I think the Brussels regulation has worked reasonably well, certainly in its amended form. I think if we were to leave the European Union, there will need to be some substitute. One possibility is that the United Kingdom should join the Lugano Convention, which is the Brussels Convention with another name, which governs jurisdiction and the enforcement of judgments between members of the Lugano Convention. But I think in reality, probably there will have to be a specific ad hoc arrangement reached whereby the United Kingdom would remain party to a revised Brussels regulation. I don't think there will be a great deal of hostility to that. Time is up. I've raced through this, probably with a greater speed than I would have wished, but thank you very much.
Thanks very much. Thank you very much, Clive. That was a huge range of stuff to go through, and I think that sets the scene very well. there's all these areas we haven't thought about. I hadn't thought about fishing at all, actually. And I'm pretty sure that the Chartered Institute of Fishermen are not talking about IP at their symposium, so we've got one over them already, which is great news. So we've had quite a look at the broader picture there and also move towards the litigation. Caroline's going to pick up some other broader IP issues, but now we're going to hand over to David, who's going to talk a bit more about some of the core rights and also some statutory interpretation points.
Thank you very much. Ladies and gentlemen, I am from that law firm that says we can't express a public view one way or the other on in or out, so nothing I say is to be taken as an endorsement of either camp. If anyone wants to know my view, please ask me afterwards. My role is to talk about the two EU harmonised rights, or the two main EU harmonised rights, trademarks and designs. And a lot of what I'm about to say is actually guesswork. Because it's never happened before, we don't know what is likely to happen. So we can see quite clearly what's likely to happen as a question of EU law. These rights would cease to cover the United Kingdom. But what would then happen as a question of UK law is still up in the air. And as far as I know, neither the in or out camp has expressed a clear view as to what would happen to the tens of thousands of registered community designs and trademarks that subsist. So the simple part is the EU law part. On the day of Brexit, were it to happen, those rights would cease to cover the United Kingdom and the various other territories designated by the United Kingdom as being covered by those rights, such as Gibraltar. We would then presumably have to have some form of transitional provision to allow those rights to be refiled in the United Kingdom as United Kingdom rights. Now, if we didn't have such a thing, then all those CTMs and RCDs would simply cease to cover this country, and clients, international clients who'd relied on that for the last 20 years would end up without coverage here at all. For trademarks, it's slightly less of a problem because they could just file them here and hope that in the intervening years no one has filed a right that would stop them from doing so, and that ought to be the case because they had their CTM anyway. With designs, it's somewhat more complicated because obviously if they refiled the design here, it would no longer be new or of individual character and it would be invalid. So whether that means all those rights just evaporate, probably not. I think the view is that the United Kingdom government would put something into place to enable you to refile, but there would probably be a fee. For those of you who do trademark and design filing in the United Kingdom, that suggests that Brexit would be 2 to 3 years of lots of work on filing, but thereafter no community trademark work and no community design work, no trips to Alicante, no trips to Luxembourg, all that work would cease. I've mentioned on the slide that I think there would probably be thereafter a drop in litigation. Obviously, anything new, lawyers get excited about, and there'd likely be a bit of litigation to work out what it all means. But thereafter, the UK becomes a less attractive place for litigating these EU-wide rights because you wouldn't be able to litigate the EU-wide rights here. The IPEC and the High Court would cease to, so that Darren doesn't pick me up on that, the IPEC and the Chancery Division sitting within the High Court would not be able to issue EU-wide injunctions. They would be UK only, or indeed, yes, UK only in those cases. So a lot of that work, the EU-wide work, would, in my view, go to Germany, possibly also to Spain, to firms that have Alicante offices. There's nothing to say that UK law on national trademarks and designs would change. The acts would stay the same. How they are interpreted may well change, and we'll talk about that just a little bit now. There are specific rules on EU interpretation that help us interpret not only the regulation in relation to designs and the regulation in relation to trademarks, but also national law. And they tell us, for example, three things. One, there is a purposive or teleological construction of statutes. Don't look at the words, don't look at what it says, look at what it's trying to achieve. And that is very different to at least the old English way of doing it, and potentially different to what the English way of doing it would become. Also, with EU statutes, we have to look at all the different language versions, and if the English language version is out of line with the others, we do have to look at the others to help us interpret what they mean, and that can make a difference to various statutes. Thankfully, it's not often the English version that's wrong. It's often the Spanish version that's wrong, interestingly. But still something to be taken into account, and also the requirement under EU construction that you interpret exceptions narrowly. So if someone says you may have a trademark but not for this, or you may have a design but not for one that's solely dictated by technical function, the exception gets narrowly defined. That is not a part of English law. So again, these statutes that English statutes we've been interpreting using EU interpretation methods because of the directive, we'd cease to do so. I mentioned earlier that we would lose our trips to Alicante and to Luxembourg. Clive has said that it's unlikely that we would join the EEA, and really that's the only hope for us if we want to continue to represent clients at OHIM, which I should now call the EU IPO, albeit that it doesn't do copyright or patents. And also the courts in Luxembourg. That would mean no more of that sort of work for any of us. Perhaps an increase in national filings, but definitely a departure of all that. If anyone is interested, my backup plan, should we Brexit, is to get admitted on the papers in Ireland, which is possible for English solicitors, and then practice out of a postbox in the firm's Paris office. That is a possibility, but continuing to file CTMs, RCDs from London as an English solicitor, not a possibility. So that was really all I wanted to say on trademarks and designs, on statutory interpretation and rights of audience, and I think my time's up in any event, so I'll... Excellent, well there we are.
Thank you. Thank you, David. We are rattling through information here, and that highlighted some of the practical problems around some of the core rights there. Whether there's going to be a rush for filing of extra registrations will be interesting to see. There's no question that the IPO's drafting legislation team are going to be petrified about the work ahead of them if they do have to start rewriting a whole bunch of law. The move to UK interpretation is perhaps one of the neutral points here. That doesn't sound all bad to me, but there we go. And the Irish solution, I think quite a few people are looking at the idea of effectively getting some rights of audience or position in other countries as well. But I think the next topic that we're going to move to, which is one that is central to a lot of the people here, I suspect, is the patent side of things, which Kevin's going to now take us through, looking particularly at some of the UPC issues. And we are doing well on time, by the way, so you can relax a little bit.
Thank you, Gwilym. Well, I was going to start by saying that I'm happy to continue to rattle along, because the UPC issue is really rather a stark one. Depending on the vote, we will decide either to leave or to jeopardize completely a project which we've been trying to achieve for 40 years, which is, of course, a rational way of enforcing patents in Europe. As I'm sure you know, I've been rather involved in this project over a few years. It is not perfect, but in my view, it is fit for purpose. So the consequences are really rather stark, and we'll come to that in a moment. I'm in the happy position, as David has said, of not being allowed to express my own view. If it is inherent in what I say, well, I can't help that. But I'm not going to express my view, but I will say this, that whichever way the vote goes, I'm a winner, whichever way. If we decide to stay in, then I get to see the completion of a project that has kept me waking up at 4 a.m. every morning for at least 5 years. And if we vote to go out, I get to retire. Happy days. Okay. This is the current timetable that the preparatory committee is working to. They will finish their work at the end of July, and they will hand over the preparations to the so-called administrative committee. There will be a sunrise period, which you've all heard about, for opt-outs, and the appointment of judges will begin in February 2017. Now, the current plan is that the formal instruments of ratification, which will trigger the commencement of the court, will be lodged by Germany and the UK in February. And the court will open for business on the 2nd of May 2017. And all I want to say about that timetable is that if it is a vote to remain in, then it is a realistic and workable timetable. So if we remain in, then we are talking about commencement in May of 2017. Now, of course, the referendum is 23rd of June, which is a long time before then. So what happens if we vote to leave? Well, as Clive has said, the procedure is to give notice under Article 50 of the TEU. And Clive, I think, very sensibly acknowledged that such are the complexities of leaving and such of the intervening political uncertainties that to complete that negotiation within 2 years is very unrealistic indeed. We're talking about a period possibly 4, possibly 5 years. Now, what is the consequence of that? Well, the consequence of that means under Article 81, if we vote to go out, it is unrealistic that we could ratify the UPCA. Unrealistic. But Article 89 of the agreement requires the 3 member states with the highest number of European patents to ratify before the project can come into effect. Now, if we vote to come out during that period of negotiation, we not only remain a member of the EU, but we also remain a member of the contracting states of the UPCA, which means that unless the agreement is completely renegotiated so far as the coming into effect provisions are concerned, it can't be ratified and it can't come into effect. So the next question is, will the EUPC project continue without the UK? In other words, despite the difficulties, all of the contracting member states agree to amend Article 89 to remove the UK as a necessary ratifier. Would it continue without us? I don't know is the answer, but let's look at the background. The UK influence on this project has been extraordinary. The original scheme for the rules of procedure for the UPC was devised in 2008 at a prolonged meeting in Venice. And that meeting was chaired, and if I can say so, chaired and bullied by Sir Robin Jacob. So the essence of what we now see as the procedure, the essence of it, was fundamentally influenced by Robin Jacob. The drafting committee for the rules that did all the nitty-gritty work had 3 UK members, more than any other country. The advisory group, which is responsible for selecting and training and overseeing the training of judges, is chaired by Sir Robin Jacob. The CMS system, which now keeps me awake every night, is led by the UK IPO. We were responsible for the fees group. So given all of that influence, is it really likely that the other members of the other members of the contracting member states are going to amend the agreement to replace the UK as a necessary ratifier? I think it's highly unlikely. And what that means is that the project will fail. And so, and I make the other point is, if we come out and don't ratify, if we come out, then of course the UK will cease to be a member of enhanced cooperation. The UK, the attractiveness of the unitary patent in commercial terms and in economic terms will be very much reduced by that. So, as I say, the consequence of all of this is that a vote to leave will simply destroy the project. And what we are left with, well, I say it's business as usual. It's the system of enforcing patents, which we've lived with and tried to change for 40 years. What happens if I'm entirely wrong and the member states get together, the contracting member states of the agreement get together and decide to proceed to make amendments so that the UK is no longer a participating party? Well, there they are. We'll obviously lose this section of the central division and our local division. UK lawyers will not be able to represent clients in the UPC because the agreement and the rules of procedure have a nationality requirement, which requires lawyers to be nationals of the EU. Now, funnily enough, patent attorneys could continue because I don't see any nationality requirement for patent attorneys who have the enhanced litigation certificate. It is likely that the German domination of European litigation will increase, and the UK-only litigation, frankly, is likely to diminish. The trend will be to enforce European patents and the unitary patent. Frankly, the trend will be to enforce them in the German courts. And it means that our influence on the development of patent law generally in Europe will diminish. So, I'm sorry, I've overrun my time, haven't I? So it's very simply put. At the minimum, if we vote to leave, the project will continue without us, with these consequences, but there is a very high probability that the project will simply be abandoned. Thank you.
Thank you, Kevin, and I think you'll agree he kept his cards close to his chest there. A couple of interesting points there. First of all, the May 2017 date. I think that was always the date that people were looking at was next year, so it's interesting to hear that we're getting that close. And a little big up to the UK involvement so far, and indeed, I think you didn't mention Kevin. Kevin himself, as we know, has been massively involved in this. So I think the comment that it may not work without us is a little bit worrying. Maybe it'll be forced to work with us. It's obviously this is the sort of thing we'd like to say. But certainly I've heard external views, for example, from German attorneys, that basically the UK will have to stay involved in some form for it to work as well. So it's interesting that even the country might view as our largest competitor takes a similar view, which is quite nice to get that kind of balance. And the clincher for me was when I heard that the court would move to Milan. That's interesting. But, as you say, we've got Luxembourg, Alicante, Milan, why not? So that's quite nice too. On the other clincher for me is that patent attorneys are okay. Brilliant. Okay, well, so we've talked about a few things already. We've looked at the broader picture. We've looked at some of the core rights now, the designs and trademarks. We've looked at the patents and, in particular, the UPC impact. And we haven't really talked that much about the EPO because, as we know, that's obviously extra EU, so it's not quite such the issue. But let's now turn to a particular technology sector, and Catriona Hammer is going to look a little bit about the life sciences side, SPCs and so on. Catriona.
Right, well, Milan. I can think of shoes and handbag possibilities. Anyway, moving on. I was asked to talk a little bit about the pharma and life sciences industry position because these industries are significant users of the IP system, and the IP system is extremely important to them. I'm in the happy position that I don't have to stand up here and tell you my personal views because the industry actually published the industry's views. So I will refer you to a joint letter from the ABPI and the BIA, which was published in the Observer on Sunday the 8th of May, just after I thought I'd got my final draft slides done. Thanks, guys. And I have to say that it was very clearly in favour of remaining within the EU. Unsurprisingly, the position was driven by regulatory issues, by facilitating getting new products onto the market, having done the clinical trials, etc. That's hugely important for the industry. And clearly the industry does want continuing access to the EMEA so that you can get a single regulatory authorization to cover the whole of the EU market. If that were not to be available, then there may be consequences for the speed at which new drugs would be brought onto the UK market and potentially the price as well. IP was not mentioned in the letter, but I guess you wouldn't expect it to be. However, I will say now that regulatory issues are very closely linked to data exclusivity, and there would be a question about data exclusivity, which is one of these areas of the law that is closely related to IP, even if it's not IP. So where do we stand? Well, I have to say my crystal ball is no better than anyone else's, but I've been having a think about what might happen. First of all, we heard Kevin's very clear presentation on All Matters UPC. Interestingly, although there's a proposal for a unitary patent, there isn't currently a proposal for a unitary SPC. Now, I remember in about the year 2000 reading a draft for creating a new patent court, and the first note I wrote in it was, what about SPCs? So I find it slightly sad that I'm standing here in 2016 still saying, what about SPCs? Clearly, at some point, industry would like to have the facility of having a unitary SPC, but there's no desire to reopen the substantive law, the concept of SPCs in order to get there. So ideally, it could be done in a simple and administrative way. Of course, if a unitary SPC were to come into force, and if we were to Brexit, so we're kind of piling up the hypotheticals here, because as Kevin's mentioned, there's no guarantee there would be a unitary system at all, then national SPCs would continue to be available in the UK, but future unitary SPCs would not cover the UK in the same way as they would not cover Spain because it's outside unitary patent, or Switzerland, for example. So that's the position on unitary SPCs. Existing SPCs are national rights, so they ought to continue in force. What about future SPCs, and what about transitional SPCs, so applications going through the process? Well, your guess is as good as mine on this one, but this is so important to the industry, and given that the industry is important to the UK economy, I do think that there would be transitional arrangements put in place to deal with pending applications, and we would need national legislation for new applications for UK SPCs. I'd also like to refer back to a point that David made, which is what then happens when you interpret the law. At the moment, we have countless references to the CJEU on SPCs, and anyone who follows this area will know that. Will we have a whole raft of references to the Supreme Court in future? Possibly. And will that result in quite a different law than the law in the rest of Europe? Possibly. That would certainly add complexity to the system, but potentially it would create work for practitioners in the UK. We'd have to wait and see. Another area of interest to this sector is the area of parallel imports. Now, clearly, parallel imports, it's not an issue that's specific to pharma and life sciences. And again, it's unclear what the position would be following a Brexit. But it is significant, particularly because pricing isn't totally under the control of the company that's selling a drug, due to issues on reimbursement, etc. So although we have a single market, it's not quite a level playing field in pharmaceuticals in the way that it would be in some other consumer products, for example. At the moment, I mean, there is a possibility that if we were to Brexit, then there might be more protection against parallel imports into the UK, depending on what would be our ongoing relationship with the single market. And again, that's not clear. So that's a thought that there might be one area where Brexit might result in a more favourable position in this one aspect. The other thing I want to mention very briefly is harmonisation. Again, clearly this is not specific to this industry. However, life sciences and pharmaceutical companies tend to file at least some of their applications in very broad ranges of countries. Not all of them by any means, but some of them. And therefore, they're clearly very interested in progress on harmonisation discussions, removal of both substantive and procedural, and removal of redundancies from the system, harking back to the fact that the industry really doesn't want to introduce redundancies in the regulatory position. Now, it's unclear whether a Brexit would have any impact whatsoever on the progress of the harmonisation discussions, because the EU is actually not greatly involved. It's mostly being done by the patent offices, and the EPO and the UK IPO are involved, and also the industry trilateral. And I suggest you ask Tony Rollins over a beer about that one afterwards, because he's been very deeply involved in those discussions. However, I would observe that the UK has been very influential in getting to a position where harmonisation looks much more likely than it ever has done before in my career. And one of the reasons for that, I think, is that the UK professions and the UK IPO tend to take a very pragmatic approach, not necessarily just we want to stick to our system in every single facet of our system because we know it and we think it's best, but more of a kind of, okay, well, we're going to have to make compromises somewhere, so where might those compromises be approach. And that has been helpful. It's also been helpful sometimes in bringing round some of our colleagues in other European countries, resulting in the EPO position and the European industry trilateral position being perhaps more pragmatic than it would have been without us. There is a concern, and certainly in my mind, that if we do Brexit, then people might just stop listening to us because we won't be so much at the heart of the European systems. It's a concern. I've got no evidence to support this. How could I have? But that's a fear that I have, that there could be not a legal impact, but a kind of a fluffy personal relationship impact that could, and as we all know, personal relationships are extremely important in negotiations, so there is a potential risk there. I was also asked to cover trade secrets, not because they're, again, relevant only to this industry sector, but they are clearly important to this sector. And as many of you will know, that there is a draft EU directive. I was actually I think we are actually hopeful that it might be more than a draft by now, but having looked on the websites, it's still draft. This is not intended to harmonise trade secret law across Europe. It's intended to set a minimum standard. And I go back to, again, refer to what David said about you have to consider the intent of European legislation. So member states will have 2 years to implement this international law. Don't know when that 2-year period will start, because it's still a draft. We don't know how that period might fit with any transitional arrangements if we were to Brexit. In practice, very little change is likely to be required to UK law if this directive comes into force. we are generally above that minimum standard, in some areas significantly. One could argue that there are provisions in that directive which are, at best, unclear and therefore likely to result in multiple references to the CJEU, and possibly not entirely favourable, particularly when you start trying to interpret the wording around the exemptions for whistleblowers. How broadly can they disclose? What can they disclose? It's simply not entirely clear in the current language. So there's arguably the fact that if this didn't come into the force in the UK, we'd have our current law, and we know what that means. On the other hand, I think we do actually increasingly work in a global environment, and trade secrets can very easily be carried over borders. For example, on a USB stick. So I do think it would be potentially disadvantageous if we're not part of that. The other area that is important here is cybersecurity, very much linked to trade secrets. These days, if people do want to misappropriate trade secrets, they normally do it electronically. Even if it is someone internally, the way they take the information is electronically. Look, I'm not going to stand here and repeat the positions that you've heard rehearsed by the various politicians on security generally, but I would say that cybersecurity is an important part of security. There's clearly also a need for balance between security, our privacy, and also employee rights. As I say, IP is not going to sway anyone on this particular issue, but it is something that is entwined with IP, as many of these other issues are. And that's all I had by both sides. Thank you.
Thanks, Catriona. It's interesting that the moment we get to the industry view and we move away from the rhetoric of the politicians and, frankly, the slightly insular view of us in IP, you get onto the commercial realities. And quite clearly, the industry view, as you mentioned, was pretty straightforward, stay. Although, interestingly, they're not too bothered about IP and it's regulatory, but that's interesting as well. What I'm getting a little bit of a hint of from several of the speakers, though, is that if nothing else, should we exit, at least we don't have to deal with quite so many EU institutions anymore, which is a bit worrying and not a great advert for the way the EU's run, but there we go. We have here the best behaved panel ever. Everyone's really running nicely to time. Caroline, I know you're worried about time a little bit. We've certainly got time for you to cover your options. You're also worried that you're going to be touching on things that weren't quite so interesting to people, but I would just, before she starts, that's not right. A lot of the stuff she's talking about are areas where I hadn't thought about it until, actually, Caroline, you raised a huge bunch of really interesting topics. There's so many things we've not thought about and discussed, actually, that she's going to touch on now that I think are really relevant. A lot of them maybe the comfort comes out, it's not going to make a huge difference, but in others, I think it's definitely worth thinking about. So you can relax into the topics and you can relax with your time. Caroline, please.
Thank you, Gwilym. As Gwilym said, there are a lot of other issues to consider. We've heard a lot about the core IP rights, patents, trademarks, designs, and they're obviously going to be affecting our everyday practice more than other issues. But there are plenty of other issues surrounding IP that will be strongly impacted if we leave the EU. And a lot of these, when I came to look at them, were rather counterintuitive. But I think I largely came to the conclusion that under some sort of reframed deal with the European Union, we could actually end up back in quite a similar position to where we are now. So I wanted to start just by briefly mentioning competition law, because I think this is one of the areas where British companies find, certainly the larger companies, find EU regulations the most directly restrictive in what they're doing. So it might be tempting to think that by freeing ourselves from the EU, we will free ourselves from a lot of that regulation. But this is just not going to be the practical reality for many British businesses. Obviously, the UK law, competition laws are largely harmonised with European law anyway, and there doesn't seem to be a great push towards freeing up competition law in the UK as a national matter. Also, there will be a very direct impact of EU regulations on many UK businesses that trade across Europe and have large markets within Europe and perhaps do cross-border deals with other European firms. So as we see with many US firms, there will continue to be a fairly direct impact of the European regulations. As has already been mentioned by previous speakers as well, if we were to remain in the EEA, we would actually be subject to many of the competition regulations in the same way as we currently are. So directly there's unlikely to be there's unlikely to be much change in relation to competition law. I also wanted to briefly touch on issues of tax and state aid, and obviously this is a huge topic, most of which is not at all relevant to IP, but perhaps where it touches on IP most directly is in relation to patent box regulations. And again, it might be tempting to think if we left the EU, we would have a bit more freedom to set up our own tax affairs, to provide more support for businesses in relation to patent related tax issues. And it's widely thought, I think, that people will be aware of the upcoming changes in patent box and the fact that they're going to become more restrictive in what you can put within your patent box to get the tax relief. And it's widely thought that this was due to some EU mechanism. And although the EU was directly involved in those discussions, it was actually an OECD ruling that caused us to think again about patent box and restrict some of those impacts. And as far as I know, there's no proposal to leave the OECD, which is a very broad international organisation, including the US, Japan, many countries around the world. So we would continue to have to comply with their ruling, and we would have to keep patent box as it's now been amended. Again, impact of remaining in the EEA would mean the rules around tax and state aid would have to be directly complied with anyway. So again, there's probably going to be little change there. If we took a step further outside Europe, of course, we increasingly run the risk potentially of import tariffs if we go too far along the state aid road, particularly perhaps in an EU that might be minded to discourage other countries from leaving. There might be an impact there. Moving quickly through these topics, which could probably occupy an entire talk all by themselves, I also wanted to mention research and development grants that come from the EU. And when I started looking at this, I wondered if I'd found a positive reason to stay in the EU. Because British business does get money for research and development from the EU. The Horizon 2020 programme is the current flagship research and development funding programme for businesses across the EU, and it has a specific stream for SMEs. And across the whole Horizon 2020 programme, they intend to hand out about 80 billion euros in funding before 2020, which is not an insignificant amount of money. So is this a reason to stay in the EU? Well, it turns out not, unfortunately, because there are a number of countries, around 7, I believe, who have associated country status. And it seems fairly straightforward to join the programme on that basis. And associated countries have all the same benefits as full EU members. So that might be a route by which British business could continue to take advantage of EU funding across research and development. So again, research and development, potentially little impact on leaving. I also wanted to list up on the slide, really, some other rights and regulations that came to mind that probably are only going to have an impact on a small number of businesses that we work with, but perhaps they might have a large impact on some of those businesses. I'm not going to talk about them in any more detail, but plant variety rights, database rights, geographical indications of origin, I think some issues around exhaustion of rights has already been mentioned. And these are all going to have to be taken into consideration if we're renegotiating a new deal with Europe, or perhaps rewritten in UK legislation. That was my very brief run-through of other issues. But the other thing I wanted to cover in my 10 minutes were to give some, I think probably one of the most important impacts were we to leave the EU would be what perceptions of the UK and IP in the UK, how they would change from the point of view of those, particularly those outside the EU. And in preparing for this talk, I conducted a completely unscientific survey of a number of contacts, particularly in the US. And by definition, my contacts over there are actively involved in managing significant IP portfolios in Europe for their clients. So they're not completely disconnected with Europe. I suspect they're not typical of the US population. But even amongst them, there was very variable awareness that there was a referendum at all, to be honest. And they certainly hadn't got as far as thinking of what the implications would be if we were to leave the EU. But the one thing when they did start thinking about it and talking about it really was a sense of frustration, because particularly from outside the EU, understandably, what they really want is a well-functioning IP system that offers value for money and enables them, their clients and the applicants, rights holders, to protect their rights across the EU as a whole. Now, obviously, we've made significant progress towards this in the past 20 years in trademarks and designs, and we're on the verge of making some very significant progress in patents. So anything that threatens to complicate a sort of pan-European IP strategy from the point of view of someone outside Europe is not a welcome step. There's also the issue of sharing information and educating particularly foreign applicants and attorneys, but also British businesses, about the impact on IP. There's a lot of myths and a lot of incorrect assumptions out there, in particular the most obvious one being that the EPO is not part of the EU, and the, in fact, limited implications of leaving the EU in terms of the current setup of European patent protection. That's not a message that has really reached them. It's not really something we've had to talk about yet. So that's going to be a big area around which we're going to have to start educating people. And obviously, should the UPC come into force, that's only going to further complicate the picture and add a further layer of discussion and education that's needed there. What also came out of my discussions with foreign attorneys is the question, really, and it's only a question at this point, as to whether the UK IP profession would remain the best place to go to seek protection when your primary focus is European IP protection. It's not a question that they seem to have thought about or really answered yet, but it's certainly one that comes up quite quickly when you start talking to people outside Europe. Finally, I talked to them a little about the impact on UK rights from the point of view of applicants, particularly who are outside the EU. And obviously, this is very dependent on the particular situation of the applicants, on their budget, on where their market is, and their individual circumstances. But largely, the thinking was that if it's a choice between obtaining a pan-European right without the UK or obtaining UK rights, then they have to go for Europe first. And the UK becomes a secondary consideration if they have a particular market here or a budget that covers the UK. I think we're largely saved in the UK by the fact that we are a significant market and the cost of obtaining IP rights nationally in the UK is relatively low. So I'm not sure that's going to be a difficult conversation to have in most cases, but it's certainly a consideration. So in summary, I think we can envisage a situation in which the ultimate outcome of us leaving the EU in these areas that I have talked about would actually be little impact. But I think we do have a lot of work to do, both in terms of the legislation and in terms of re-educating those who use our services to get back to the position that we're in now. Thank you.
Caroline. I can see that the SEPA team is swung into action the microphones, so we go into those in a couple of minutes. And the gentleman on the sound desk, we're going to shift to the microphones on the panel podium thing over there in a minute, if that's okay. And I've stopped wittering. Thanks so much for that, Caroline. As I said, there's a whole bunch of angles that we don't perhaps think about. The patent box is something I was involved in a lecture on quite recently, which, apropos of nothing, was remarkable mostly because by the end of it there were 9 speakers and 2 people in the audience. So it remains a fascinating topic. It's that intersection between IP and tax that really brings them in every time. The other interesting thing, irrespective of anything, was the power of the OECD, was quite terrifying because this is not relevant to today, but just out of interest, on the patent box, they were basically saying that even though the legislation is not in place, all those changes we're hearing about for the beginning of June will come into force, despite the fact there's no law, because the OECD says so. I just don't understand how that works, and it's quite scary, actually, but there we go. The other thing I'm particularly interested in, thanks for doing it actually, was your canvassing of external views. That's fascinating. I was in Chicago recently and I asked a couple of people, what do you think of Brexit? And they just said, well, what do you think of Donald Trump? So it was an interesting exchange of views after that. The frustrations is interesting. Just when just when we think we're going to get an IP system that works, what are you guys doing? And certainly I had a chat with a Polish friend. It might have been you, Magda. I'm not sure, when we're looking at the Skexit, the Scottish thing. And the comment was, if Scotland leaves, can Poland join instead? Which is an interesting comment. So I think that's interesting. And the point you make on myths is a very interesting one as well. But we've had to deal with that, as we know, for many years already. The UK, as we all know, is not part of Europe, and apparently you can't use it because it doesn't have the euro. It's something I've been told by many overseas attorneys before now, who I don't know who might have told them that. So it's interesting. We do have to keep myth busting. We do have to keep reminding people about the EPO and so on and so forth. We know what's going on here. So we're going to shift now to a Q&A session open to the audience, first of all, and then there's a few points that we came up with we want to talk about possibly as well if time permits. But I did say at the beginning it's not going to be interactive. It's not totally true. Anybody who's got any questions, we'll run the microphone down to you so that it goes onto the web, and we'll start here. Thank you. I'll stay here.
Hello, Arthur Boff, Phillips and Lee. I just wanted to raise a couple of points relating to the Unitary Patent and the Unified Patent Court, which I don't think came up previously. You have a situation where if we leave, to get the same geographic extent of protection, which we would have had if we'd stayed, rather than being able to just get a single unitary patent, we'd have to get a new unitary patent and something covering the UK, either a UK patent or a European designation of, UK designation of a EP patent. Now, immediately there's a consequence there on renewal fees. There's also a consequence on rights, because Article 26 of the Unified Patent Court Agreement gives a broader scope for contributory infringement proceedings than we currently have. It would allow you to, if we stayed in, go after a company in Germany who are supplying something to enable an infringement in the UK. Whereas if we left, you would not be able to come after that, because under the UK law, of course, it's strictly supplying the UK for infringement in the UK. So we'd end up in a position where, to get the same geographic extent, you'd have to pay more and you'd have less rights, which I don't think most of our clients would consider a good deal.
No, I agree. Secondary infringement becomes a much easier thing to prove under the UPC agreement and in the UPC court than if we continue to enforce nationally. I agree.
Darren. Here it comes. Pass it along. You've got to unwrap it each time.
Darren Smith, EIP and sometimes IPCAT. I've got lots of questions in my head about effect of Brexit on UPC, because it's the hardest thing to imagine, because we're imagining the effect of something that hasn't happened on a system that also hasn't happened. But I have heard people say that the UK might ratify anyway in order to avoid the problems that you were talking about. You clearly think that isn't likely, and I wonder whether you might be able to expand on why you think that's unlikely. And sort of related to that, I think you suggested that if it does go ahead anyway, the UK bit of the Central Division would move to Milan, presumably without an amendment of the agreement, but the coming into force provisions couldn't be changed because the agreement can't change. And there seems to be a tension between those two, and I suspect you have a reason for thinking both of those, and I'd be grateful for clarification of that as well.
I didn't realise until this moment that I've got a problem with my hearing. So I'll try and answer the questions one by one, and if I've got it wrong, let me know. The first thing you wanted to talk about is it feasible that the UK government, following a vote to leave, would in any way ratify the agreement? And the purpose for that, presumably, would be to allow the preparatory proceedings to continue and then presumably leave when the negotiations. I think that's unrealistic. And nobody I've personally have talked to has said that this sort of tactical, friendly, pro-EU ratification would be on the table. Now, the second point was, does the agreement require amendment to allow the Central Division to move to Milan? Was that it?
Yes.
Yes, it does.
And do you think the agreement could be amended to do that, but you don't think it could be amended to change the coming into force provisions to mean that the UK ratification...
Well, there would be no point in changing the location of the Central Division to Milan if they don't also change the ratification provisions, because without changing the ratification provisions, there's no... The court can't begin business. The project can't start. And what I didn't actually make clear is that at the moment there's a lot of different views within Europe amongst the contracting member states of the agreement, whether they really want to participate, or at least yet. And we won't get, even if Britain remains in, we won't get ratifications from all the contracting member states, certainly not first. So then you have to say, well, realistically, if those countries, if those countries are really doubtful about whether they want to participate, will they enter into a wholesale renegotiation of the agreement effectively to exclude the UK? I seriously don't think they will.
Thank you. Could I ask a quick EU IPO question as well?
Go.
This, I suppose, is to David. You explained that people who practice before the EU IPO by virtue of being a national legal practitioner will not be able to practice anymore. What would be the situation for existing European trademark and design attorneys who are on the OHIM list? Would they be automatically kicked off, or could they do something about their place of business to stay on?
The simple answer is I don't know the answer to that question because I'm not one and I haven't looked at it. But I will, and I'll send you an email and let you know my views.
Thank you very much.
Just while we're waiting for any more questions, that's the worst acronym in the world, EU IPO. I mean, don't acronyms, aren't they meant to sound like something? That's over. It's horrific. Any more questions from the floor? So that could we covered everything. That's brilliant. Okay. Well, if in that case, we'll just knock around a couple of comments that we wanted to follow up with, and we're not going to run this on too long because we know we're keeping you from the beer. So I'm going to walk over there. And can I just share that? So we knocked around a couple of things we might want to talk about, but actually there's a few things I thought that came out of the discussion here that might be worth starting with. And we've had, among talking of acronyms, EEA and EFTA have been bandied around a lot. We're having mixed stories here. I think and this is, I genuinely don't know the answer. This is not me asking a clever question. which of those two is more attractive if they're mutually exclusive, and what are the real prospects of actually them replacing our membership should be Brexit?
I'll dive in first. I think for a lot of people, the EEA is the worst of all possible worlds because we remain bound by European legislation. We remain bound to implement the decisions of the Court of Justice, but we can't influence any of those things. We can't refer cases to the Court of Justice, and we don't participate in the legislation that's being enacted in Strasbourg or Brussels. So I think for a lot of people, the view is to be in the EEA, yes, makes things easy for those of us who file community trademarks, because we could continue to do so. But that seems to me the singular benefit of that particular type of membership, where we sign up to all the rules but are not in a position to influence any of them.
So far as UPC, the position, again, is extremely clear. In its opinion, which I referred to in the slides, number 1 of 09, the Court of Justice decided that if you're not a member of the EU, then you cannot participate in the agreement or the court. So it's simple as that. EAA doesn't provide you with an alternative route.
Could I just express a personal view about this? I'm just being very, very careful in terms of what I say. But it does seem to me to be very short-sighted. I mean, obviously there are significant benefits in having a universal patent system and a patent court along the lines that Kevin has outlined this evening. But it does seem to me to be incredibly short-sighted for views to be taken, and there may be good reasons for this, why, and I'm assuming here there's a Brexit, why the remaining countries of the EU and the United Kingdom, other countries as well, maybe the countries of the EEA, perhaps the other member states of the EPC, don't get together and renegotiate a much broader international patent system, which is not going to be a European Union system. I mean, it just seems to me that that is the way ahead, rather than have a European Union system. And even if the UPC went ahead, surely and forgetting about the European Court for a moment, because I think in many ways the European Court has been a tremendous handicap on the development of the European Union, you know, why shouldn't one still look beyond that and say there should be a much broader patent system which is going to cover Europe in its largest and broadest extent?
I have nothing to say against your personal beliefs, Clive. But you've got to remember that the UPC project originally did extend beyond
that's right.
And the Court of Justice has said that to extend that agreement to non-EU member states is contrary to the treaty. And that's a reality. So to renegotiate another wider agreement would inevitably end up with an agreement which is contrary to the treaty.
Well, that in a way, sort of, to my mind, encapsulates the whole problem with the sort of the centrist nature of the European Union, that it's so bound up within its own jurisdiction, and that sometimes forgets that there's a world outside. And the worst culprit in that is the European Court.
Could I just say something on that? I mean, there are, as I mentioned, there are harmonisation discussions, not to create a single world patent. It'd be lovely if you could have one of those, but I don't think it would happen in my lifetime.
That's not going to happen.
But there are harmonisation discussions trying to simplify the processes, and there's no legal reason why those discussions can't continue, even if there's a Brexit. The question is, though, whether we would have as much of a say in the development. And again, it becomes very hypothetical.
But I wonder whether a Brexit would be the spur to that. You know, you can't ignore the United Kingdom in terms of its importance for intellectual property, its size as a trading nation, as the 5th largest trading nation in the world.
Yeah, but if you're only filing in 3 or 4 countries...
Yeah, I know, but we have considerable negotiating influence. It would be an incredible shock to the European Union if we were to leave. I don't think that really that has got home yet. And I think in those circumstances, we have very substantial bargaining power, if it is played properly and used properly.
I guess I can't speak about patents at all and don't purport to, but in relation to designs, I've been involved with the Standing Committee on Trademarks, Geographical Indications and Industrial Designs at WIPO in Geneva for the last 7 years. We've been trying to negotiate a treaty to harmonise design filing practice, something you would have thought was very, very easy indeed. But we continue to stumble, and whether the UK is influential or not is... a matter for debate, I think, in that particular negotiation. But the reality is that anything involving international legislation, because that's really what this is, treaty making, is incredibly difficult and often, at least in my experience, relating to all sorts of things that aren't actually there in the room. It's all about other aspects, other political aspects, and not actually about design law at all in what we're doing. So we failed again 2 weeks ago. It goes back to the General Assembly in October, and let's hope something comes of it. But the point of that long-winded story, for which I apologise, is that trying to do anything on an international basis is extremely difficult, extremely time-consuming, and my sense is if you scrap the UPC and start from scratch, it's going to be another 40 years down the track, and I plan not to be here.
Neither will I. No.
I've certainly witnessed through SEPA, and I know, Catriona, you certainly have, that the UK does have influence in various IP spheres at the moment. Very influential at the European Patent Office in view of some of the things going on there at the moment, and close involvement through the right people, very dynamic people being on the right committees and having the right impact and influence. At WIPO, to the extent anyone has any influence, I think the UK does have a good ear, but usually is knocked out by some of the countries, what they're called, the B, no, not B plus, the other ones, whatever those.
Let me give you an example of the difference. I don't know whether anybody here has been involved, but WIPO have been trying to reach agreement on the extent of privilege for donkey's years, and in particular to extend the privilege to patent attorneys and in-house lawyers. And you may remember one Michael Dowling of the AIPPI who thought that he could make some progress with this before having to retire. Well, he retired, and he's still, I think, trying to make some progress with WIPO on that. But it's been years and years and years of failure on a simple issue. Let's define and extend the scope of protection to patent attorneys. We started with the UPC, and we have enormous problems within Europe because privilege varies as between French concepts and English concepts. So we started with a clean sheet of paper, and we drafted our own code for privilege, which will apply to the UPC court. And we did that we had some useful comments from your profession, but basically we did that very simply within the context of these UPC negotiations. And I agree with David, if we were waiting for WIPO to come up with a coherent code, we'd be waiting forever.
But in terms of Brexit, there's been, I think, two views expressed, actually. Catriona, I think you reflected the industry view that this will make us less influential globally.
It might.
Not
It might.
It might, yeah, but not specifically, I think, in relation to IP, but more generally. Clive, you're actually interestingly, you said the opposite, that you might find that we have more bargaining power because we're not part of it. To the panel, what do you think in terms of our influence on the global IP world? Is Brexit going to have a major impact, and if so, which way?
again, coming back to the very narrow topic of the UPC, if that project continues without us, then I think our influence is much diminished, because I think most of the litigation will go to Germany, and there will be no UK judges or lawyers involved in UPC proceedings. So the development of patent law will be not at all influenced in Europe, I think, by the UK. We'll have our own, obviously, we'll have our own national cases. Will the law develop in the same way? I doubt it.
But I cannot see that the situation, and I've had a lot of multi-jurisdictional cases involving the EPC, particularly for American clients. And of course they have to litigate in the different jurisdictions. That may or may not be a handicap. Time and time again, the litigation partly resolves itself by saying the jurisdiction where we want to litigate, it's a good jurisdiction, we understand it, is the United Kingdom, i.e. England, the patent court in England. And I really cannot see that changing. Now, I'm not saying that UPC is undesirable as a concept at all, that's not the point. But if we leave the European Union, I just do not see that attraction of the United Kingdom under the existing patent scheme, under the existing litigation scheme, continuing to be of considerable importance.
Catriona, you saw lots as president of CEPA, went to lots of
Yeah.
meetings and saw things. What's your view on our influence?
I think think we do have a lot of influence at the moment. There will be negotiations during any transitional period, and clearly that will be a critical time. My fear is that IP will not be anywhere near the top of the list of the government of the day's negotiation plans, so that we'll get what we absolutely need to, things like SPCs continuing, etc. But I'm not optimistic that something like, let's take this opportunity to renegotiate the terms of reference for European-wide patent protection is going to be on anyone's hit list for that transitional period. I just don't think IP is going to be that important.
I suspect that there will be exhaustion. I mean, with due respect to Kevin and the tremendous work he's been doing, I cannot see another generation falling into Kevin's shoes with the object of a total renegotiation of another patent system.
No, I can't say.
Can I try Tim?
Tim Roberts. This question of the UK's influence, it seems to be taken for granted that we do best by convincing the European Union to take our line. And I think that must be open to question. Certainly, if you go to WIPO, as people have remarked, discussions at WIPO are generally unprofitable. But you go and hear something like the Nagoya Protocol being discussed, you will hear the EU put its point of view, not necessarily particularly impressively. You very rarely hear from the UK. And it would be good to hear the UK, and I think there must be some advantage in expressing the UK's opinions directly in these fora, rather than by influencing the EU to adopt as much as you can.
Okay, thank you. Can I just go back to a little anecdote? I was heavily involved in copyright reform in the early 80s, in the late 70s and the early 80s. And it was fascinating that there was a sort of gradual sea change over that period in terms of the Department of Trade. This was Mrs. Thatcher's government. I think by the end of the 70s, there was a sort of recognition that the European Union was here to stay. It wasn't simply a curious thing that we had joined. And I noticed at the time that civil servants in the Department of Trade and in the Patent Office, it suddenly dawned on them, and the question that they always asked was, is there a European dimension here? And I won't say they began to derogate from their duty, but they suddenly seemed to take the view that they didn't have to make decisions because this was a European subject, and because it was a European subject within the competence of the Commission, that was where things would be decided. And it was very curious the way in which that sort of happened over that particular period. And I remember a view being expressed to me by a fairly senior person within the Patent Office shortly before the '88 Copyright Act was passed, and saying this is going to be short-lived. This is really a European matter. And particularly within certain concepts, such as unregistered design right. And they said this is going to be dead in the water, because they, of course, reached a very half-baked arrangement in terms of qualification for unregistered design right.
So Edward at the back has got a question, but just while the microphone's going up, that's quite interesting. So we're looking to a certain extent at the idea that if we were to Brexit, then we'd have to stop hiding behind the EU and actually step up and do a bit of talking ourselves, which is an interesting idea. Edward.
Is it switched on?
Yep.
Yes, it is. I'm Edward Lyndon Stanford. I have long retired. This discussion is about Brexit, and it is being run by the Chartered Institute of Patent Attorneys, and I think we should think quite a lot about the effect of Brexit on patent attorneys. And the fundamental thing is that we will lose UPC. Now, I see UPC as being potentially a great benefit to British patent attorneys. One of the problems we have had for as long as I've been practicing is the relatively low rates of patenting in the United Kingdom compared to France and Germany. And the reason, in my experience, is that the courts were just too expensive for the smaller inventor. And so once you've explained what it would cost to litigate a patent, they don't patent. The UPC potentially will provide low-cost litigation. That is greatly challenged, but I have worked as a patent attorney in Germany, and I've worked as a patent attorney in Italy. And in both those countries, it was possible, and is possible, to litigate fairly cheaply, much, much cheaper than in the United Kingdom. And I think that if we have UPC, we as patent attorneys, or you as patent attorneys, will be filing more patent applications, a benefit to the profession and also a benefit to the country. Thank you, sir.
Thank you. Any comments particularly, but I was going to open that into two separate questions, actually, if I can, because there's both these topics came up when we were talking before this. The first one, if anyone on the panel wants to talk, this is where you have to become thought leaders, by the way. So the UK does have maybe not the world's greatest patentee innovative output, but we have a fantastic creative output, and we're well known for that. Interesting question. We all tie IP, innovation and creation, all inextricably linked. You can't have one without the other, and a strong system and so on. Out of interest, does anyone have any views on what the impact of Brexit might be on the UK's kind of innovation/creative output, if any?
It's one of those things that you have a legal framework. I just cannot see it stifling creative output. That will remain, whatever the political scenario and the constitutional scenario. But Edward made a very interesting point about, and of course this has come out in the context of IPEC and before at the Patents County Court, good ways of resolving patent disputes which are not going to cost an arm and a leg. One area where the United Kingdom has always been very much to the fore, and the rest of Europe has rather lagged behind with one or two exceptions, and that's arbitration. And I think that's a strength that we should play to in determining IP disputes. That's not a Brexit point, it's just...
Thank you. Caroline.
Going back to the creative economy point, just an opposing view, and I know this is straying way outside IP, is that really by being in Europe, we have the free movement of goods and people around Europe, I think, contributes to our creative economy. And I think cutting ourselves off and sort of insulating ourselves as an island can only take away from that in a general sense. That's my thought.
Thank you. The other half of that question, which I think Edward touched on, and probably one that, in a sense, I think was one of the initial questions we raised in this symposium, was the potential impact on our own business. And we have several businesses represented on the panel here, with patent attorneys, an element of the trademark side of things, litigation, and the industry in-house experience as well. I'm going to start from the end, actually, and just say what your view, starting from Caroline, where do you see the impact, positive, negative, short-term, long-term, of Brexit, shall we say? You have 30 seconds.
Thank you. Can I borrow your crystal ball? It's very difficult to say. There's a huge short-term impact, obviously, on the changes in legislation. Longer term, I think, inevitably, IP in Europe will become more German-centric. So I think British firms either have to move in that direction, possibly physically, or shrink, essentially.
Yeah, I think essentially the same. One thing I'd say is that the UPC is going to cause businesses to review their European filing strategy. And in some cases, that actually might mean that they just don't file they file less in Europe, because the position in of Europe globally is perhaps not as good as it was when we started this project. And I certainly don't really rate the UK's chances of climbing higher up anybody's filing lists if there is a possibility of a unitary patent and we're not in it. As Kevin said, there is a question of whether there would be a unitary patent. And then you also have to think about the fact that how are you going to deal with transactions of unitary patents, and which law is going to apply? It's not going to be UK law. So I think there could potentially be an impact on transactional law as well. And then simply pragmatic reasons, where do you put your European IP department as a multinational? You're probably less likely to put it in the UK. That's a personal view.
I agree with much of what Edward has said, that this is a fantastic opportunity for both lawyers and patent attorneys if the UPC project goes ahead. The point I want to make isn't one that I've made yet, and that is on languages. It is not the fact that every single local division that we're aware of will work in English is realistic, because we know that 85+% of patents granted by the EPO are granted in English, and all of these courts will be prepared to work in English. But my view is that the Americans and the Japanese and the Koreans are more inclined to instruct you people to get involved in their litigation with English as your native language than they will in the other divisions which are working in English as a sort of a second choice. If we go out, will those German divisions continue to offer English as an option, as a language of proceedings? Questionable. Very questionable. And don't forget that the consequence, the reason why the Germans have been prepared to offer English as a second language, because there's a recognition by the German profession that within a very short period, a few years, English will be the only language that will be used in this court throughout Europe. And that puts you in a very, very strong position indeed compared to your competitors abroad.
Thank you. There's two people fighting over the microphone now. I love that. And someone in between them looking a bit scared.
Absolutely. Absolutely. So I'm Matt Dixon. I'm the chair of the joint CPRIT-MAR Business Practice Committee. There you go. And I'm a partner at HGF. On the point of the language, of course they're going to continue to use English, because they're not using English for us. It's not our English, the British English. It's the international English, possibly the American English. It's just about it being the lingua franca. So there's no way those courts are going to say, no, this must be in German, I think, because they see the business opportunity if it's UPC wide. And on the point about influence of the UK, I think this goes back to Catriona's point. We see as patent attorneys all the time how influential the UK economy is in the context of Europe, because we see all the people that are going, I'll maybe just do France and Germany as the countries that I care about in Europe, or actually Germany will do, and I've got a national filing programme just for the one country. So perhaps we have more practical experience of how influential the UK looks on the world stage than perhaps other businesses. Thank you.
Aaron?
My point is completely different, but is also about the effect on the UK patent profession. And it's a small point, but I think it's a very important point, and it hasn't been mentioned, which is, so the latest draft of the proposed regulation on the European Patent Litigation Certificate, which it is assumed that the Administrative Committee will adopt when the court is constituted, currently lists a large number of qualifications held by UK patent attorneys on the grandfathering list, which means at the moment, if all goes ahead according to current things, a lot of UK patent attorneys will have rights of audience as European patent attorneys with a patent litigation certificate. Now, I'm supposing that all of those will be crossed out if the UK left. I suppose it is possible that, inertia might mean that it would go through and effectively the entire UK patent profession would be qualified. But I think it makes quite a big difference one way or the other. And you seem to be agreeing with me that that's completely unknowable at the moment.
I just don't know whether they would delete them. I haven't a clue. As I said to you earlier, the strange thing is there's no EU nationality requirement for patent attorneys. You merely have to be qualified to practice before the EPO, and you have to have the certificate, or you have to show that you're grandfathered in. Whether they would change those, I haven't a clue. There is a risk, of course, that they might, but they might not.
Perhaps they'll run the courses in Milan and we won't be able to get a visa.
I miss that.
Perhaps they'll run the courses in Milan and not be able to get a visa.
David.
Again, I touched on some of these issues in my presentation. I think if you are a trademark attorney or a patent attorney who files community trademarks and designs, then that business will all go away. And you would have to replace it with either national work or shrink the size of your practice. If you are a patent attorney who files trademarks, or a trademark attorney who only acts for local UK businesses and only does local UK work, then I think nothing would change. But I'm not sure there are many of those still in existence. I think for the rest of us who do a bit of filing and a bit of litigation and a bit of other things, life would become inexorably more dull. And I don't just mean trips to Alicante, because they get boring after a while, but the ability to be responsible for pan-European litigation, to run the Samsung-Apple dispute from London, that evaporates. And we're left here being, again, English lawyers just doing English law, or English attorneys just doing English attorneying. There's one point that I wanted to say just in response to the influence issue, which is, if we stay within Europe, I think we have the opportunity to have greater influence than we do by the government taking even more seriously the sorts of appointments it makes to Europe. There are member states that are very serious about the way they appoint their judges to the Court of Justice, about nominating people to be advocates general, about seconding people to OHIM and the other European institutions. And I think we could be significantly more serious about that if we wanted to increase the sort of influence that we have. So take, for example, the Irish system is to send to the Court of Justice a High Court judge, Irish High Court judge, and on return he or she is automatically appointed to the Supreme Court. And your time in Europe is seen as getting you ready for the Supreme Court, and is considered a good appointment. That's not the case here. To be appointed the judge of the Court of Justice, in the General Court, doesn't even come with a knighthood. That's how the government looks at it, although they did give Nicholas Fulford one on his retirement. So I think there are elements there. If we want to have more influence, there are ways to do it.
In terms of the effect on the professions, I'm a solicitor, I'm not a patent attorney. I can well see the importance of the UPC to the patent profession. That apart, I mean, I suspect life will just go on as it always has done. I'm old enough I began practicing in 1973, which sort of more or less coincided with the United Kingdom becoming a member of the European Economic Community. And certainly for the first 5 years or so, it had very, very limited effect. I think some clients wanted advice upon European law. I think European competition law was probably disproportionately important at the time. And of course, we had the European Patent Convention. We had European patents. And I suspect we'll probably go back to that. I don't see a fundamental diminution in work. And probably for the first few years post-Brexit, I think there will be a lot of work, a lot of transitional work. And I think for the legal profession in particular, there will be a whole issue of renegotiating contracts, advising on the interpretation of contracts and so on and so forth. Personally, I would not be sorry to see the loss of the European Court. I don't think the European Court has necessarily been a force for good. I think it has been a considerable handicap in the development of community trademark law. That's purely a personal view. And I think there are probably better ways in which one has a superior court to govern the community trademark system. So that's the position. I think it would be a pity to lose the UPC. Because I think probably that, with all its faults, and it has a lot of faults, it's probably the best that could have been negotiated.
Thank you. I think the only thing I'd add to that is that when I was discussing this with my friend who's a regulatory lawyer, he just pointed out that change is always good for lawyers. And it certainly is in the short term, but whether that's a good reason to make change is a different issue altogether. We'll probably start winding up. It's been a long session. Thank you so much for the attention. Thank you to the panel for remaining amazingly, admirably neutral. Who knows what they're actually thinking? We did say we'd do the vote again, so out of interest, let's have a re-vote. How many people's minds have changed? Who still thinks we should vote in the EU? Who thinks we should vote out of the EU? 1, 2, 3. We've got an extra one. We've got an extra person. It's happened. We've got a changer. I think it might be Jeremy from Kilburn Strode. Got you. Another one. Great. Excellent. I've got to just quickly, before we go, mention a few more SEPA events. We've mentioned the Brazilian Ball, the Gala Dinner, and the Battle of the Bands, of course. There's also a few more sessions coming up. Insight on second medical use enforcement, 18th of May. Understanding the patent document. It's a bit late, isn't it, really? Yes, you don't. 26th of May. Why cyber attacks are a business risk, 2nd of June. And critical developments in IP in India, the 9th of June. Thanks to a few people, to IP Centrum again for the sponsorship, to SEPA and Celia, your great team. Thank you very much for organising it. To our lovely SEPA girls running around with the microphones, great work. Thank you very much indeed. To the Sound and Vision people, thank you, by the way. I know how much you must have enjoyed this, so thanks. Big thumbs up from a major new IP enthusiast on the camera there. And of course, actually, what a good venue as well. But finally, of course, to a fantastic panel. That was really thought-provoking. It was wide range, with a lot of work in, and actually, I thought, very interesting as well, which is a triumph for the topic like this. So thank you very much to our panel as well. And now there's drinks outside, and if you rush, you might get a beer.